The next case we're going to do is Holder versus Humanitarian Law Project. This is a much more recent case, and it also shows how really difficult First Amendment and speech jurisprudence has gotten. It from the very simple times with Shank, where it was simply distributing a leaflet and was a law that criminalized that unconstitutional, to what we're considering in this case the complexity of First Amendment cases has gotten uh, monumentally um, more complex. So in this particular case, the Humanitarian Law Project, and others were among a group of plaintiffs who were providing material support to two groups which the federal government had identified as terrorist organizations. Those terrorist organizations were the Kurdish Workers Party, or the KWP, or the LTTE, and I'm going to just do that to not obliterate their name. Um, and both of these organizations, according to the federal government, engaged in illegal activity, but they also engaged in a variety of lawful activities. So they were a terrorist organization who did stuff that was good and did stuff that was bad. Um, the group in this case, the Humanitarian Law Project, uh, attempted to get an injunction to the enforcement of a new law, and that new law was the Anti-Terrorism and Effective Death Penalty Act. What this law did, and why the Humanitarian Law Project sought to get an injunction against its enforcement, was that it made a crime for anyone to provide, anyone or group to provide support in a material sense um, to any of these organizations, even if that support that this group would supply was to help in the legal activities which these groups would undertake. So the KWP and the LTTE would undertake. The group in this case, the Humanitarian Law Project, provided material support in the fact that they taught groups legal means to actually solve conflict. They taught them conflict resolution in a nonviolent sense. None of what the material support that the Humanitarian Law Project was giving these two organizations would be directly correlated to any of their illegal or terrorist activities. And even the federal government agrees that that's true in this case, that the help that the Humanitarian Law Project was giving was in no way directed at benefiting these groups in terms of their illegal activities. It was only an attempt to provide them alternative means to sort of resolve conflict. So what the Humanitarian Law Project argues is that the issues in this case, or that the statute in this case, was unconstitutionally vague, and therefore ultimately, while it violated their First Amendment rights, it was unconstitutionally vague, and no reasonable organization would actually know what the law in question meant. And the reason why they were stating that the law was vague is that it provided that it said any material benefit, but that it also included service, training, and specialized knowledge. So if you gave these groups service, training, or specialized knowledge, that was going to fall under the AEDPA. And the Humanitarian Law Project was saying, well, we're teaching them nonviolent conflict resolution. We don't know if that is service, training, or specialized knowledge. We don't know under the law, and the law doesn't inform us, and so we're seeking an injunction against it because we claim that it is constitutionally vague. So the issue in this case is the Anti-Terrorism and Effective Death Penalty Act unconstitutionally vague in the way that it would be applied to the Humanitarian Law Project. And a majority of the court in a 6-3 decision says that no, this law um, is not unconstitutionally vague, um, because primarily it's meant to cast a broad net. It is supposed to, and the intention of as it was drafted was to prevent any form of benefit to these groups outside of a medical exception, um, because any materials given to these groups would ultimately further their terroristic and illegal activities. And the argument here being that if you were to give individuals any sort of resource that they didn't already have, or that they would have to expend their own resources to acquire, that means that they could then shift that resource that they would have had to use to their illegal activity. And therefore, any help that you give them will ultimately benefit the illegal activity which this law is attempting um, to preclude. There are 3 justices in dissent, and it's the 3 liberal justices, so no real shock there. The 3 most liberal justices, Ginsburg, Breyer, and Sotomayor, who is on the court at this time as well. They agree with the majority that the law isn't unconstitutionally vague. They're like, well, you're right. It's actually pretty clear. However, it's a violation of the First Amendment because it punishes criminally a political position. And this is the reason why the Humanitarian Law Project and other groups like it seek to teach these people and these groups nonviolent means of conflict resolution, is because they want these groups to engage in nonviolent means of conflict resolution because they disagree with the terrorist activities that they're engaged in. And so what you're doing is you're prosecuting a group of individuals or organizations for attempting to express a political opinion. And that is at the core of what the First Amendment is supposed to protect against. Ultimately, that side doesn't carry the day, and the majority upholds the Anti-Terrorism and Effective Death Penalty Act and upholds the fact that applying any sort of service to these groups, like the Kurdish Workers' Party, is a violation of this law. And humanitarian groups like the Humanitarian Law Project and other groups could be prosecuted criminally for providing any form of advice, training, specialized knowledge to these groups in the long run.